testing across the street today.
Yeah. Tyranny versus justice or truth. Or
Oh,
something like
awesome. We're gonna miss that, aren't we?
that. Mhm.
Burton.
Let's do it.
Okay, sounds good. On the record in the matter of Cheltenham Law versus James Burton, 25-01279. Answers for the record.
Good afternoon, and thank you, Your Honor. Daniel Best, P58501, and on behalf of Plaintiff Cheltenham Law.
Good afternoon, Your Honor. Benjamin Folger, Greg Crockett, on behalf of defendant James Burton, standing to our right. If it please the court, our intern Talia Epps is present as well.
Thank you. And today was the date that was scheduled for a non-jury trial. We're not able to resolve it, is that correct?
That's correct.
Oh,
Oh, sorry, why am I answering? I'm so sorry.
it's how we have it.
Sorry.
That is correct.
Okay, so we're ready to proceed.
Plaintiff is,
Okay, any preliminary matters before you proceed?
not the plaintiff, Your Honor.
You can call your witness.
Very good. Your Honor, I call Colleen Cheltenham. It helps if I know how to pronounce my client's name to the stand.
Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes,
And you can have a seat.
Ms. Cheltenham, can you state your name and spell it for the record?
certainly. Colleen Cheltenham, COLLINCHELTENHAM.
And are you familiar with Mr. Burton, James Burton, the defendant in this matter?
I am.
And how are you familiar with him?
Mr. Burton came to my office in, I think, April of 2022 and retained me as counsel.
Okay. And can you just walk through the routine process?
Sure. What we do first before we do retention is we meet the client and do a free consultation. I don't recall at the moment if that was in person or over the phone, but one of the two ways is how I met with James. And during that consultation, we discuss the case, we discuss maybe the process, and then our retainer fee and hourly rates. And then after that, we send a retainer fee agreement and electronic pay link to the potential client for them to sign at their will and then pay the pay link at their will.
Very good. Handing you what is labeled as plaintiff's exhibit A. May I approach the witness, Your Honor?
You may.
Can you describe that document?
Certainly, this appears to be my retainer fee agreement with Mr. Burton.
And what were the general terms of that agreement?
The terms of the agreement is, one is we laid out a payment plan for the retainer fee itself, but we have the retainer. I don't know how much detail you want me to go into. I'm sorry. Do you want me to go through the exact terms or just generally?
I was hoping the more specifics, the retainer amount, the agreement, that sort of thing.
Okay.
I mean, the agreement for payment, excuse me.
Thank you. So on this particular retainer fee agreement, we had a retainer of $8,000. We had a down payment on signing of the retainer of $3,000. And then we had a breakout of $1,000 payments through a schedule in the retainer fee agreement. So Mr. Burton could meet that $8,000 retention fee. And then on the next paragraph, it gives our hourly rate for me, for myself, my associates, and my staff. And then continued on the second page is under paragraph 4, it tells us that he's going to be billed hourly and bills will be sent monthly. Paragraph 5 explains that retainer fee breakout, and it also explains what happens after that retainer fee is depleted. And then paragraph 6 tells us what he will be billed for, the types of services and things that he will be billed for. Paragraph 7 is just a reflection on us submitting statements each month, and that those statements would reflect all activity and expenses incurred. And that And then paragraph 8 is if the retainer fee is depleted, we'll bill monthly. We again articulate that. And any unused funds would be returned to the client. Paragraph 9 is that we may withdraw if 2 or more payments are missed, or if there's a balance due of $5,000 or more. Paragraph 10 is that we're granted a lien in any property settlement which wasn't valid in this case. This was it was a guardianship issue that turned into really a custody issue and parenting time issue. And paragraph 11 tells us that we may designate other legal assistants and attorneys as appropriate. Paragraph.
Well, let me stop you. I don't.
Yeah, that's okay.
That goes beyond the payment.
Okay.
I would like you to identify what paragraph 21 provides for in the agreement.
Paragraph 21 provides that the agreement and its terms cannot be modified unless modification is in writing and signed by both the attorney, which would be me, and the client, who is Mr. Burton.
Was the retainer fee paid?
It was never paid in full. My recollection is that we received a $3,000 down payment as appropriate. And then there were 2 other $1,000 payments received from Mr. Burton.
Let me ask you, does Cheltenham law, do you maintain business records?
We do maintain business records.
Okay, and is the information contained in those records entered at or near the time of occurrence?
Yes, they are.
Is the information entered with the person responsible for entry of that information into the records?
Yes, it is.
And is it the ordinary course of business of Cheltenham law to maintain those records?
It is an ordinary course of business to maintain those records.
And I'm handing you a packet that I have labeled as Exhibit B. And can you describe what that is?
Exhibit B appears to be a packet of the various invoices that my office sent to Mr. Burton. Looks like June of 2022 through, one moment, I'm sorry, May of 2023. This exhibit C that's behind here, that we can hand it.
Oh, yeah, I'll hold on to that for now. And I would apologize, Your Honor, I did not ask to approach. May I
You're fine.
approach the witness?
Yes,
Does the court want me to ask to approach?
you're almost there anyways.
I was sort of thinking that, but I didn't want to say it out loud. So what are these invoices? What do they represent?
They represent each and every time entry that either myself or my staff at the time entered in Mr. James Burton's. So anytime we work on something, we would enter a time period. The hourly rate is automatically produced within the system, and then it gives a total for that each line item.
Okay, and that was services rendered in accordance with the retainer fee agreement.
That's correct.
And throughout this, I note that there are listings on the last page of each individual invoice with a payment history. How describe going to the very last page has a payment showing the payment history. Can you just describe to the court the payments that you received on this?
Sure, and I'm looking at the last page. Is that correct?
Correct.
All right, so what happens, there's a trust history on the last page. And there, underneath that, there is a credit history. So sometimes what happens is when we receive a client retainer, somebody may have assigned it to what's called a credit, and that is still deposited into trust. So that the very bottom line shows the credit deposit of $3,000 on 4/27/2022. Up above that, this is under the credit history, which this is underneath the actual trust history. And then there's a credit withdrawal of $3,000, meaning we withdrew that, we placed it into trust. And that's, those funds are still held in trust. We moved it from this credit history to the trust history where it should have been deposited. And then up above that, there is the trust history. And then we have deposits, a trust deposit, and we've our payment from trust means we've drawn that from the trust account to pay the invoice.
Okay, and again, I thought you said you've received a total of $5,000. Did you apply $5,000 towards your bill, your company's bill?
So we did, but we didn't receive those payments all up front. So there is a payment history, and I have some paperwork in my file that has just the payment history on it. And my recollection is that when I reviewed that document, there was a payment of $3,000. Then there were two other payments at two different times, two different dates. So they may not be reflected on this particular invoice. I don't recall exactly the date that those payments came in.
Well, the last page again identifies monies being received on June 2nd of $800, June 9th of $200, and then September 2nd, two payments, one of $750, one of $250. Would those be the dates that you received those payments?
That it could be. It looks to me like, and I understand why there's confusion. When I look at this, there's a transfer of money from trust from the credit history into the trust balance, and then payments are deducted from that. So I think it would actually help me look at that payment history sheet that I have in my file. Maybe I can make that one clear. This is a little confusing the way it's laid out on the.
Can I approach the witness room?
I just want to use this to refresh my memory. So I'm looking at a report. It's not something I produce. It's a report that comes out of the system I have. It's a software application called My Case. And My Case sits on our system. It takes in all the payments, meaning people pay a pay link. They receive a link. They pay that link, and then they can make other payments on that. And I can produce a report from that on just the payments received from a particular client. So when I printed out this report, it says that on June 13, 2022, I received $1,000. And then on another payment on June 13, 2022, I received $3,000. And then on October 13, 2022, I received $1,000. And those are the only payments that were received in this particular file.
And do you know how those payments were made?
I do. I know for sure that those payments were made in an electronic format by a credit card. Two, I think, were from Visa. One was from MasterCard. And I know that because I reviewed the reporting prior to coming to court today.
And how does Mr. Burton receive these invoices?
He receives them in multiple ways. We send out, this whole system holds our invoices in our all of the financials for a particular client. So once we enter our time, I create the invoice and I do the invoicing myself. Nobody else in my office is allowed to do invoicing. So I create the invoice through My Case, and it is submitted through My Case into a link that the client would have to click on, open it, and view the document. I also submit it through My Case via email. So they also send the client an email with the invoice. And I also send it sometimes, if I feel like the client needs a prompting, a text. So especially if there's a payment due. So through My Case, there's a link within that system on the invoice, and if I click it, it sends a text as well. So all three.
Do you know, did you use all three with respect to Mr. Burton?
I did on multiple times, and I know that for sure because I reviewed my the reporting for Mr. Burton in My Case, and there's a history that gets attached to an email, and I can actually view the history. Gets attached to the invoice rather. So I can click on view history of one particular invoice, and it will tell me what date and time I sent the invoice. It will tell me what date and time the client viewed the invoice or viewed the link, meaning they clicked on the link and then viewed the invoice. I hope I answered your question.
You did, yes, thank you. I'm handing you what is labeled Plaintiff's Exhibit C. Can you identify what that document is?
This document is an order to withdraw from counsel from Mr. Burton's case in Eaton County Circuit Court, which was held in front of Judge Garcia.
And when was that order entered?
This order was entered by the court on March 30th, 2023.
And I'm assuming that was a result of a motion you filed?
That was, initially I tried to have Mr. Burton sign a stipulation or for me to withdraw, and the majority, well, so, but I didn't get a response, and so I ended up filing a motion with the court. We had a hearing in front of the judge on this.
Do you serve defendant a copy of that motion?
I
Mr.
did,
Burton?
yes.
Did he appear for the hearing?
My recollection is that, yes, he did appear for the hearing, yes.
Okay. And this order, what does it provide about attorney's fees?
Specifically related to the attorney's fees, is one paragraph at the very bottom. It says it is further ordered that all attorney's fees due and owing to Cheltenham Law PLLC will be paid as agreed upon by counsel and interested party James Burton.
So up until the point of this entry of this order, what objections had you received from Mr. Burton to the services outlined in the invoices you were providing?
I hadn't received any objection to the services, and I hadn't received any objection to the invoicing that we provided. It was only after that period of time, after the order was entered and after I sent, I'm sorry, probably going too far, but after I started communicating about collection work, that I received objection.
You said you started communicating about collections, you said?
Yes.
And according to your records, what does Mr. Burton owe Cheltenham Law?
I cannot remember the exact dollar amount. Is it might be in my invoice in here? Hang on 1 second, please. The last invoice, I'm looking at Exhibit B, and I'm looking at the last page of that exhibit in the packet. It is an invoice dated May 3rd, 2023. There's a balance due and owing of $9,268.39.
Okay. And just given the timing, all the services in that were rendered prior to the order of withdrawal being entered?
That's correct. Yeah, the services, yes, they were.
Very good. I had no further questions for this witness at this time.
Your Honor, if we may have 10 to 15 minutes to review the invoices with our client prior to cross-examination. This
Absolutely.
is the first we received.
No worries, off the record. You can take the stand. You're prepared for cross exam?
Yes, sir.
Okay, you can proceed.
Good afternoon, Ms. Shelton.
Good afternoon.
Do you still have your plaintiff's exhibit A, the retainer agreement in front of you?
I do.
If you look at paragraph 21, please. Your attorney asked you about that. It says, this agreement and the terms of the engagement shall not be modified in any respect unless such modification is in writing and signed by both attorney and client, correct?
That's right.
So isn't it a fact it would be a breach of this agreement for you to ask Mr. Burton for $8,000 that's not in writing?
I don't understand the question.
Isn't it a fact when you asked Mr. Burton for an additional $8,000 beyond the retainer at the outset of this case, that would be a breach of that paragraph?
That is not correct.
Do you still have the your invoices?
I do.
If you could look at October 13th of 22, please.
October 13th of 22, I have it.
Okay. Under due date on the top right corner, it says see payment plan, correct?
That's right.
If you look at the second page on this one at the bottom left, it starts outlining a payment plan from October 22nd to June of 2023. Is this payments Mr. Burton made?
No,
What is this?
when I decided to put a client on a payment plan, and from the retainer agreement, you'll recognize that we did put Mr. Burton on a payment plan of $1,000 a month. So when I decided to do that, there's a button I click in my case. I can create a payment plan within my case to do that. And my case is a software application. When I click that button and I create a payment plan, it outlines the payment plan, which is clearly marked on the second page. It says payment plan. And you'll see that October 14th, 2022, it says a manual payment was successful of $1,000. Everything else underneath there is a payment due and owing. And those outline November 14, 2022, December 14, January 14, February 14, March 14, April 14, and May 14, and then a final payment for this particular invoice as of June 14, 2023. The payments that are in dark have not been made, or the outline of the payment structure that is dark have not been made. The October 14, 2022 payment was made. In status, it says it was successful. That was the only payment received on that invoice.
Let
Okay.
me stop you. Is there a copy of this for the court?
Yes, Your Honor.
This
Do
was
you want me to move to introduce the exhibits at this time?
Yes, there was exhibit B, and then I think you had a C as well as a.
I have A, B, and C, Your Honor.
Yeah, you can move for those
I
omissions.
move for admission of A, B, and C.
Any objection?
No objection.
Thank you. You were just asking her about, was it exhibit B?
Exhibit B, the October 13th, 2022 invoice, Your Honor, and page 2 at the bottom left where it says payment plan.
Okay, you can proceed.
Thank you, Your Honor. Ms. Cheltenham, just so I understand, you say October 14th of 22, there was $1,000 payment made?
Yes, and that looks like it was applied to that invoice, yes.
How come on the next page, Ms. Cheltenham, under the trust history, you don't show payment of $1,000?
Because it could have been that there was a manual payment made on October 14, 2022. I'm not really certain why it wouldn't be reflected. Well, let's see, 10/14/2022. There's a payment from trust on 10/13/2022, that's $1,000. So I'm not 100% certain that that was an application from the 13th to the 14th. I'm not quite sure.
I'm sorry, I don't understand. What do you mean by manual payment?
So it could be that a client goes in, but it would be reflected in the payment history that we have. So a client can go in and make a payment on their own as a manual payment instead of a trust transfer, and we would. So that's called a manual payment. And the system would pick that up as a manual payment from the client.
By that, do you mean someone brings a payment physically into your office?
It just means the client made a payment on their own, so from their end. If someone brought a payment into the office, then it would be reflected not as a trust transfer, it would be reflected as something else. This is just an application of that payment for that payment plan. Does that make sense? I hope I'm being clear. So the application of $1,000, it looks like to me, when I look at this invoice, we had a draw from trust on 10/13/2022 and an application on 10/14/2022. That was that payment that was made and applied.
So on page 2 of the October 13th, 2022 invoice, it shows a manual payment of $1,000 was made.
Correct.
If you could then look next to the October 30th invoice, the 746, the second page.
Hold on one second. October
It
30th.
should be the one right after.
Yep, okay, go ahead.
On the second page under account summary, it still doesn't show that $1,000 that was paid, does it?
Well, it shows on 10/13/2022, it shows the same. It's just a history of what has transpired. So that payment of 10/13/2022 to me is the payment that was applied to that first installment.
Ms. Cheltenham, doesn't 10/13 of 22 say payment from trust, not trust deposit?
Right, so
So that would,
it's,
go
may I
ahead.
answer the question?
I'm sorry.
Okay, so if it's a payment from trust, obviously we transferred that. So we made a transfer from trust.
Right.
And I'm taking a stab at why it says manual on the prior invoice. You see that?
Right, so, but your testimony is on 10/14 that he paid $1,000, correct?
I'm thinking that's the application from that $1,000 draw from trust.
Respectfully, which is it? Because earlier you said that he brought in or made a payment of $1,000.
I think my testimony was that typically when I'm talking about a manual payment, it's that a client has made a payment electronically. I didn't say he brought it in or didn't bring it in. That wasn't what I recall my testimony was.
So is that an error then? If your software shows on October 14th, he made a payment of $1,000, but it's not showing up on any of the account summaries of his payments?
No, I don't think it's an error at all. Again, what I think it is that reflecting back and thinking about it, there is a trust draw the day before. And then an application the day after. So a trust draw is like, let me explain how I do the invoicing if I could for a moment. So not the invoicing, but when a deposit is made into trust, we hold it in trust. My case doesn't actually hold the funds. My case is just an application to track payments. So if the application of it came out on the 14th, I think it's the 14th. But there was a showing on the trust history on the 13th. I don't know exactly why that would happen, but that's what that is telling me when I look at this invoice. So when I go in and pay an invoice, I might click, if there's $1,000 there in trust, I'm gonna click to pay that $1,000. I have to actually manually type in $1,000 payment on that date, and then it will apply it.
Cheltenham, I'd like you to look again at the October 13th, 2022 invoice, please.
I am.
On the second page, at the bottom right corner in bold, it says balance due 78/20/89, correct?
That's what it says.
And then if you look up above it, it says unpaid balance forward is 73/75/61, correct?
That's what it says.
Can you explain the difference between these two?
Well, if you go down below, it says the time subtotal on that invoice, time entry subtotal, $1,440. Then there's an expense of $5.28. That gives the subtotal of $1,445.28. That's just for this invoice. Then there's a balance forward, and if you look up above that, it says unpaid balance forward, $7,375.61. When you look at that small box that I'm looking at on the right, with the two bars around it, where I said time entry, expense subtotal, then it says balance forward. So that's the application of that balance forward. It gives a total of $8,820.89. I mean, I can do the math, but I think that's accurate. And then I applied the $1,000, and it gave us a balance of $7,820.89.
Okay. You said it was your testimony that you're the only one that creates these invoices then, is that correct?
That is correct.
That Mr. Burton never objected to these invoices. Isn't it true he objected when you demanded an additional $8,000 from him?
No object. You keep on saying that, but I've heard no testimony about the demand. She's stated that she demanded, and there's been no testimony that.
I'll
anybody
ask.
made the demand.
I'll ask then, Your Honor. Ms. Cheltenham, isn't it true that prior to the conclusion of the $8,000 payment plan arrangement, you asked Mr. Burton for an additional $8,000?
I don't recall asking him for an additional $8,000.
Isn't it true, Ms. Cheltenham, on December 9th of 2022, in a text message with Mr. Burton, you told him you owe the firm over $8,000, not just $1,000?
What was the date of text message?
December 9th of 2022.
December 9th, 2022, then it does make sense. I would say you owe the firm about $8,000.
And isn't it true that you said not just $1,000, you owe the firm over $8,000?
Yes, that's accurate.
Isn't it true that Mr. Burton told you when he first started, you told him it would be $8,000 and he paid you $7,000 in payments and owes you $1,000 to make the $8,000?
That's what he said.
And then isn't it true, he says, are you saying I owe you $8,000 more? And your response was, your retainer is $8,000, that's not what litigation costs?
I believe that's accurate.
Isn't it true he told you, you told me the entire cost would never go over 10,000?
That's what he said. Yes, that's what I recall.
Isn't it true you told him that?
I told him I didn't think it would go over that.
Isn't it true on December 9th of 2022, when during this discussion, you also told Mr. Burton, quote, so if you're telling me you aren't paying your bill, you can stop contacting me right now, end quote?
Yes, that's what I told him.
You then told him you would be filing a motion to withdraw from the case next week, correct?
I believe so, yes.
And you didn't file a motion until February of 2023, though, correct?
That's probably correct. I was trying to give him time to pay the bill.
And isn't it true, Mr. Burton, in that message said to you, when I first talked to you, you did not want to say it will be $16,000 or more?
I don't remember his exact words, but I do recall that being something along those lines in the text message.
Isn't it also true, he says, I don't think you're representing me right, I will find a new lawyer?
I believe he said that, yes.
Your Honor, would we be exhibit 1 or A?
One. Infancy and A, so. Yeah, one.
We have it for today.
Your Honor, I would move to admit the defendant's exhibit 1.
Any objection?
I would like to hear the testimony and basis for it to admit this before I would, so I object at
agree.
this time.
I don't know that this was,
I don't know if
Something that
I
was
will
even presented
object
to the witness.
ultimately, but I do
May,
object at this
may I
time.
approach Ms.
Yes.
Shelton? Ms. Cheltenham, I'd like you to take a look at this. Is the date at the top December of 2022?
Yes, it appears to be.
When you look through this, does this appear to be the conversation that you had with Mr. Burton?
Yes, it appears to be.
And the contents of the conversation are about the questions I just asked you regarding the price and your motion to withdraw.
That appears to be correct.
I would move to admit defendant's exhibit 1.
I have no objection.
Defendant's one is admitted.
Ms. Cheltenham, isn't it true after October 14th of 2022 that Mr. Burton made 2 cash payments at your office of $1,000 each?
No, that is not.
You still have that text message exchange in front of you where Mr. Burton says he paid you $7,000, correct?
He does, yes, he says that.
Why did you not dispute that he paid you $7,000 in those messages?
One is because during this texting, I didn't have my records in front of me, so I wasn't sitting in front of my computer so I could look it up. So something responded to him. Two, whether he paid $7,000 or not wasn't the primary issue for me at that time. It's addressing the fact that he seemed to think, or seemed to be articulating, that he was only supposed to pay 8, which he didn't do, by the way. And then on top of it, it was addressing whether we're going to move forward with my representation. So I just didn't address the issue.
According to your fee agreement, Ms. Cheltenham, on page 2, paragraph 5, isn't it true it states after the completion of the full retainer fee payment schedule is made totaling $8,000, client will pay invoices on the balance due?
Yes, it does. Yes, actually, it says, let me just read the whole paragraph. If a balance is due and owing on a particular invoice, payment is due at the rate of $1,000 monthly until the retainer fee of $8,000 is paid in full. After the completion of the full retainer fee payment schedule is made totaling $8,000, which by the way never happened, client will pay invoices on the balance due listed in the invoice.
Isn't it true that Mr. Burton was still making payments to you?
At what time?
Isn't it also true,
Wait,
Ms.
I'm sorry, I want to back up.
There's some clarification.
I just need clarification. At what time are you saying?
prior to the time you asked for another $8,000?
I'm going to object. She has continuously stated that her statements was the firm was owed over $8,000.
Mark, she already established that she'd asked for an additional 8, and she just asked for clarification of the question.
You're talking about these text messages?
No, I'm talking about her fee agreement, Your Honor.
No, your question about that she asked for over $8,000.
Did she ask for an additional $8,000 prior to his completion of the payment?
Right, and my question is, are you asking her, did she ask for this in the text messages, or are you talking about a different
Just
communication?
in general. Your Honor.
Okay, just in general, your objection was as to whether or not she
Well,
established that she asked for $8,000?
She has never, she has stated she did not ask specifically for 8,000, that she asked for her bill to be paid, which was over 8,000.
We'll allow her to clarify that.
Okay, can we please repeat the question? So I can-
Sure, Ms. Cheltenham, your fee agreement states that after the completion of the full payment plan totaling $8,000, the invoices will be paid monthly, correct?
That's what it says.
Isn't it true, prior to the completion of the payment plan, you asked for an additional lump sum from Mr. Burton?
What I asked for in December of 2022. On page 2 of your exhibit 1, I'm saying your current invoice is over 8,000. You know that because you've seen every invoice I send you every single month.
So isn't it true, Ms. Cheltenham, by asking for additional money outside of the initial agreement here in a lump sum, that would be outside the scope of the fee agreement, which says that the invoices will be paid monthly?
It said, let me just go back to the language. The language states, client will pay invoices on the balance due listed in the invoice after the $8,000 is paid. First of all, Mr. Burton breached his agreement with me by not continuing to make the monthly payments. So he was already in breach of that agreement. The invoices were accumulating, and by December, he owed over $8,000. That's a true story, an accurate statement.
Nothing further from this witness.
Thank you. If you can just go to page 1 of Exhibit A. It has the payment plan that indicates there's $1,000 per month to be paid. When should have that $8,000 been paid?
October 1 of 2022.
Okay, and that's before the text messages,
That's
correct?
correct.
And if you go to Exhibit B, how much were you owed as of November 29th, 2022?
$8,775.89.
And that was the last invoice provided prior to the text message exchange? Correct.
That is correct. Yes, that's accurate.
And I'm just curious, there's on almost every invoice, there's a number of items under a category, non-billable time entries. What are those?
Your Honor, I'm gonna object. I believe that's outside the scope of redirect.
Repeat your question.
On every invoice, there is a section called non-billable time entries. And I believe it's proper. He went through these different sections of the invoices. I'm just asking about another section in the invoices that he cross-examined.
I'll allow it. The objection's overruled.
Those non-billable time entries are time written off entries. So I think in almost every single one of Mr. Burton's invoices, I would write off time to assist with the cost of litigation. So it says non-billable because there's a button I select in that time entry where you select non-billable. Non-billable time, it's just we're not billing for that time entry on this invoice for a decision that I.
Very good. And then it was identified that you did not file your motion to withdraw until February. And the text was from December. How long did you try to get a stipulation from defendant, Mr. Burton, prior to filing that motion?
I don't remember the exact time frame. I do know for sure that my paralegal at the time, Deb, had reached out to him after we drafted the motion. I know we sent it to him electronically to sign, and I know I reached out to Mr. Burton again before I filed the motion. So at least 3 different times we reached out to him to try to get him to sign a stipulation to withdraw.
I have no further questions, Your Honor.
Okay, this witness may be excused. I can call your next witness.
Your Honor, I have no further witnesses. Plaintiff does move to amend its pleadings to comply with the proofs.
Will you be calling any witnesses?
Yes, Your Honor, I would call Mr. Burton.
You raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
You can be seated.
Mr. Burton, can you please state and spell your name for the record?
James Burton, JAMES BURTON.
Is the court picking him up? Okay, Your Honor.
That goes to her. It doesn't come to me. The mics do not amplify in the courtroom, so he's got to speak louder if he can't hear.
Mr. Burton, when did you hire Ms. Cheltenham?
April of 2023.
What was that case about?
It was about temporary guardianship for my daughter.
And why were you willing to pay $8,000 to Ms. Cheltenham?
Because I love my daughter. I raised my daughter since she's been 3 years old. And so I was willing to pay her back.
What were you intending to receive from Ms. Cheltenham's services?
To get my daughter home.
Was Ms. Cheltenham the one who represented you, or did she send an associate to court with you?
She represented.
Were there times, in your opinion, she appeared unprepared in court proceedings?
Yes.
Can you describe for the court what those were? How was she unprepared?
I can recall a time where we went to court and she forgot her paperwork. So the judge was really upset at her and had to reschedule a court date. It was another time that she filed a motion and she didn't file it right, so had to wait a couple weeks extra just to see my daughter.
Let me stop you. You said that there was a time where she didn't have her paperwork. What paperwork are you referencing?
For the case, basically, I don't know exactly what paperwork that she needed for the case, but when we went to court, she told the judge she didn't have what she needed for the case.
That was what she said. I don't have, Judge, I don't have what I need for the case.
Yeah, basically, yes, the judge got mad at her and told her, why she wasn't prepared.
Okay. And do you remember when that was?
I'd say maybe in May of 2022.
May of 2022?
Yeah.
Okay, and then the other incident you said, that there was a filing, a motion that was
Yeah, she
filed?
was, filing a motion.
The motion, do you know what the motion was for?
I believe it was for, seeing my daughter.
Was it a motion for parenting time?
Yes, it was for parenting time or,
What made you believe that it was not filed appropriately?
because she
properly.
sent it to me in a text message, said that the wording was incorrect, so the judge denied it.
She told you that the wording was incorrect, so
Yeah.
the judge denied it, okay. You can think, Counsel.
Thank you, Your Honor. Do you recall the hourly rate you were paying Ms. Cheltenham under the fee agreement?
As far as I know, she said $400, but I don't recall her ever saying it was that much.
When you noticed she was doing these things that caused the court to reschedule, or there was issues with the motion you mentioned, how did that make you feel in regards to paying $400 an hour?
It upset me. It upset me. 'Cause I feel I was paying for things that was out of my control.
She ever text you about any issues with any of the documents?
Yeah, she texted me actually about an issue with the documents that she had to redo some documents.
Do you recall what that was about?
Not per se. I know maybe it was for like I said, for parenting time.
Would it refresh your memory to take a look at the text message exchange between the two of you?
Yeah, it probably would, but
Absolutely, you don't need to.
Let me know when you're ready, Mr. Burton.
yeah, this would have been for parenting time,
What's the date of this text message exchange?
June 2024.
What's the full date?
June 24, 2022. Sorry.
And what does Ms. Cheltenham say to you in the text message at the top?
And she received the order back that the judge rejected it due to issues related to the case caption.
Also in this text message exchange, Mr. Burton, do you recall talking with Ms. Cheltenham about Dr. Fugate?
Yes, I do. With Dr. Fugate, she also, I think I have that in text. I know I do. It was for, I had to set up a psychic evaluation. And it was a matter of $900. And she told me she'd pay half. If she had to, I can pay the other half.
Regarding Dr. Fugate specifically, Mr. Burton, I'd like you to take a look at the second to last page of this text message. Do you see or recall having a conversation where Ms. Cheltenham discusses her invoices with you?
What are you asking?
So do you see the part of the discussion where she discusses Dr. Fugate with you?
Yeah.
And do you see above that where she asks you if you're paying her invoice?
Yes.
Well, how does Ms. Cheltenham respond about if you've called Dr. Fugate? After you say, yes, I left a voicemail for Dr. Fugate, what does Ms. Cheltenham say to you?
Actually, I'm telling you, I will do. not pay the $8,000. So basically, she told me that, she'd do the case, but I haven't paid the 8,000. So that's what our agreement was for $8,000.
At that point in time, had you just retained Ms. Cheltenham?
Yes, she was retained at the time.
Your Honor, I would move to admit defendant's exhibit 2.
Any objection?
Yeah, no objection, Your Honor.
Minutes to the minute.
Burton, did Ms. Cheltenham, during her representation of you, make any statements that made you feel she was not zealously representing you?
Yes.
What were
couple
those
different
statements?
times. She told me a couple times I should just let the defendant of the case, my daughter grandmother, keep her. She don't believe that I'm gonna win the case. Basically, I should just, give my daughter to her mom.
When you met with Ms. Cheltenham, what was the agreement about the price for her services?
She told me that it'd be $8,000, and I asked her a couple times because I didn't want to pay a lot of money. She said she promised me it'd be 8,000, but if it do go over anything, it wouldn't exceed over 10,000.
Was there an agreement about how the $8,000 was to be paid?
Yeah, she told me to pay $3,000 down and $1,000 a month,
How much did you ultimately pay her?
$7,000.
Now, you heard the testimony of Ms. Cheltenham that you only paid $5. Is that true that you only paid $5?
No, that's not true.
Do you know how you paid the other $2,000?
Cash in her office.
Do you know when that would have been date-wise?
I'm not for sure, but I'm thinking just if I can recall, it had to be like in November, October somewhere.
Was that, how many payments was that you made in her office?
2.
And how much were they each?
$1,000 each.
Of
The
the,
3,000 I paid in cash, so
You said 3,000 in cash,
yeah,
and you don't remember when that was?
that was the retainer fee. That was.
Oh, you paid 3,000 and then you had the monthly payment?
Yes.
Okay. Are you asking about monthly payments?
no, Your Honor, I was
Okay.
asking about payments beyond 5,000 Ms. Cheltenham.
Got it.
Mr. Burton, did you have a chance to review Ms. Cheltenham's invoices on the break here?
Yes.
Of the invoices you've seen, do you see credit for the full $7,000 you paid?
No.
Are you familiar with the text message exhibit that I previously asked Ms. Cheltenham about regarding the fees?
Yeah.
Did she dispute in that message that you paid her $7,000?
No.
Did there come a time when Ms. Cheltenham asked you for more than the $8,000 you agreed to pay her?
Can you rephrase that?
Was there ever a time Ms. Cheltenham asked you for $8,000 more than what was in the fee agreement?
Yeah, she did in December. She asked me for another 8,000. That's how I found out.
Was that
That's what she
before?
asked her.
Was that before or after you concluded your payment plan arrangement with her?
After.
It was after you paid the money?
Yeah, after I paid
I'm
her.
gonna object. He did not complete the retainer plan. He's testified he's paid 7, the retainer was 8,000.
So Mr. Burton,
So objection sustained.
Did the fee agreement provide by its plain language, Mr. Burton, that she could ask for an additional lump sum? Was there a time you asked Ms. Cheltenham or her office for access to the online portal to see her invoices?
Yes.
Were you able to get access to that site?
No,
Did her office grant you that access?
no.
When was that?
I'd say, December and January, February,
Of what year?
2022, and, just recently, I asked again.
I'm sorry, you said what month?
It was going, so December and January, and then I just asked recently.
Was that this year?
Yes,
For your guardianship case, did you ultimately have to retain alternate counsel?
yes, I did.
Was there a time in February of this year, or, I'm sorry, February of 2023, where you reached out to Ms. Cheltenham via text message?
Yes,
At that point in time, had you received an order of her withdrawal as your attorney yet?
but when, can you repeat that, please?
February 8th of 2023, had you received an order from her regarding withdrawal as your attorney from the court?
Yeah, I think that's when I got it.
Would it refresh your memory to take a look at your text message with Ms. Cheltenham that day? Let me know when you're ready, Mr. Burton. Mr. Burton, on February 8th of 2023, did Ms. Cheltenham send you any message as to whether she represented you or not?
Yes, and she told me, she did not represent me anymore.
Did she tell you what you needed to do as far as contacting the court?
Speaking for myself, I don't know.
In the first paragraph that she sends to you, Mr. Burton, what does she say at the end?
She said she don't represent me anymore. Of course, get a hold of them directly. So she told me I would turn, I terminated what she said, and I need to call the court directly
Mr. Burton,
myself.
I'm sorry, Mr. Burton, I'd also like to direct your attention to the message immediately below it for February 28th of 2023. If you'd read that, what does Ms. Cheltenham say about the motion to withdraw?
She said, well, not really, either way, I'm not working for you, so please make sure you take care of this on your own.
I'm sorry, Mr. Burton, you're reading the wrong message. Can you read the next message, please?
I'm mailing you a motion to withdraw. I will email it also. I tried to withdraw the second order by the court. It rejected it because your signature was not on it. So we're not allowed to have a hearing. So I will let you know when the hearing is scheduled.
So, Mr. Burton, it says, strike that. Mr. Burton, just for the record again, what does it say about why the court rejected it?
Because of my signature.
What about your signature?
Said it wasn't on it.
And did you sign that document?
No. recall getting documents.
Mr. Burton, do you recall if you were billed for this motion to withdraw?
No, I don't recall.
Would it refresh your memory to take a look at the invoice?
Yeah.
Just for counsel's purpose, we're handing the witness the invoice for May 3rd, 2023, invoice number 888.
Motion to withdraw.
If you look at the first page, Mr. Burton, do you see any charges for a motion to withdraw?
Yes, I do.
What do those total?
$20.
How about for attorney fees? Do you see
Where would I
any,
find that?
do you see any line items on the first page where Ms. Cheltenham talks about drafting a motion or filing a motion or a notice of hearing?
Council, I mean, it says there was 235 billed. It's
So
on
you'll
the,
stipulate to that?
it's on the exhibit.
Okay, all right. I'd move to admit defendant's exhibit 3,
Which is,
which is the text message between Mr. Burton and Ms. Cheltenham on February 8th of 23 and February 28th of 2023. All in one document.
I have no objection.
admit it.
Ultimately, Mr. Burton, I think I asked you this. Did you ask to retain alternate counsel for the guardianship matter?
Yes, I did.
Who was that?
Talking about it.
Objection, Your Honor. It's not relevant to this action.
Well, Your Honor, what we're saying is he had to obtain additional counsel at an extra cost, which if anything should be reduced from the amount Ms. Cheltenham's asking for due to her deficiencies and initial breaches in the agreement. And unpreparedness in court here. The questions are
You said you
very
prepared what?
unpreparedness, the substandard work that he's testified to.
I don't know that you actually established that.
I think that's a stretch for two instances that he's claiming that the client has not had a chance to address. I don't see there's any relevance to, it would have taken more work and more time for my client to have gotten the ultimate order.
If I can, Your Honor, through the text messages that were admitted, she tells him on several occasions that she no longer represents him, even though there's no motion even filed to withdraw. And you see in the text message that he reached out to her and she said to handle it on your own.
Okay, you're talking about the February 8th, 2023 text message. When she said, I no longer represent you,
Yes, Your Honor.
you terminated me.
And the previous text message that I admitted where she says to no longer contact me, that was in December.
That was on exhibit 2.
Yes.
That's exhibit 1. The December is exhibit 1.
I'm sorry, Your Honor, the exhibit 1.
Okay, where are you referencing when she says no longer contact me?
Or other text message.
Oh, I think you're talking about here, where it says, if you're telling me you aren't paying your bill, you can stop contacting me right now. Is that what you're
Yes, Your
referencing?
Honor.
Okay. So the full statement is, if you're telling me you're not gonna pay your bill, you can stop contacting me, not stop contacting me.
Well, I think it's also inferred, Your Honor, from the next exhibit from June 24th of 2022, when he's asking about Dr. Fugate, and she says she'll do it, but he's not received the $8,000. That's a refusal to perform.
June 20.
You
Exhibit,
saying she didn't offer any?
I'm just
You're
reading her
saying-
message
you're
to
saying-
Mr. Burton.
Let me go back. You're saying because the exchange about whether or not to set up just like the psyche valve, which she said she would assist with, is that what you're talking about?
But she says, Your Honor, on page 4. I'm sorry, page 5. James, I'm telling you I will do it, but you have not paid me $8,000. At that point, Mr. Burton had been making payments and was in the payment plan with Miss Cheltenham. We're talking about what? 2 months into after retaining her,
This was June
24th of
24th,
2022.
2022. You said 2 months into the payment plan.
Right, the fee agreement's dated April, and this text message is June 24th.
What's the date on this?
This is the
June
text messages from
24th.
June 24th, 2022, where he and your client are going back and forth about his inability to make contact or get it, I think, the appointment set up with the Dr. Fugate. And its counsel saying, or arguing that the statement here, James, I'm telling you, I will do it, but you have not paid me $8,000. That goes towards what? Because she said she will do it, and you're saying that she didn't do it. Is that your argument?
She says she's not gonna do it, Your Honor. She says,
That's not what she said. She says, I'm telling you, I will do it.
but you've not paid me $8,000. And
She
then,
didn't say she wouldn't do it. She said you would do it. That, to me, it's a reminder. I'm gonna do it, but don't forget you owe me $8,000, or you haven't paid the $8,000, whatever.
all right, if I may inquire of my client
You
just
may.
briefly to further this. Mr. Burton, what were the reasons that you needed to seek additional counsel?
I just feel she wasn't representing me like she should. Several times she told me just to, give up and give my daughter, let my daughter stay with the grandmother and give her to, someone else like her mom. Due to, she just didn't feel that I would,
With Miss Cheltenham, had you gotten your daughter back? With Miss Cheltenham, what was your opinion about how she was advocating the case? Did you believe things were proceeding appropriately?
No, I don't.
Did you ultimately get your daughter back?
Yes, I did. Within 2 court dates after hiring a new lawyer, I got it back.
How much did you have to pay your
No
additional
objection,
counsel?
Your Honor. Relevancy, that has no relevance whatsoever. You'd had to pay more to my client.
Well, I think I established a foundation, Your Honor, from him as to why he needed to seek additional counsel.
I don't think you did, because all you did was go back to a text message where she said that she would make a phone call to the doctor because he was allegedly having issues getting contact with the doctor. She said, I would do it, but you have not paid me $8,000. If I read the full context of the conversation, he goes on to tell her he doesn't want it. And she says, I'm just telling you that I will bill you for the time it takes me to take care of it. And he says, I don't want to get charged for the phone calls.
Right, Your Honor, and then I asked additional questions of him as to why he felt that he needed to seek additional counsel.
I recognize that, but him feeling, because he personally didn't believe that she was doing the job that he believed she'd have been doing, but he is not in a position to tell me if a lawyer was doing the job based on his own, those statements. Doesn't tell me what happened. You're telling me that she filed something that was rejected. And then I'm reading into the exhibits that you provided. It sounds like it was an order that was rejected, not actually her filing or motion that was rejected. It was an order and it was rejected because of a caption, which we easily could have rejected any one of your filings for a caption. That doesn't mean that you're doing a poor job as an attorney. So this is I don't think this is enough for me to feel that I need to bring in that additional information. I need something more substantive. And I don't know that he's in a position to tell me the quality of an attorney's work. I don't think is he an attorney?
No, Your Honor.
So how can he tell me if the attorney was doing his due diligence or not?
If I can ask it follow-up questions as to the order that you mentioned, Your Honor, an
Absolutely.
additional document. Mr. Burton, was the order that the case captain was correct on, was that the only issue?
But I say it wasn't.
What were the other issues?
It was so long. But I can't remember, like I said, when she went to court and then had her file papers in order and that motion right there. I can't really recall it being so, it's been a long time.
Nothing further for this witness. Thank you.
About cross-examination.
Thank you. Mr. Burton, are you testifying that you never saw any invoices from my client? You
Yeah,
testified to the extent that in December of 2022, you asked for online access.
Yes, and I wasn't granted, I was kicked out of the system.
All right, so prior to that, were you able to view and receive invoices?
Yeah, like the invoices that I have that I was saying, it showed that I owe 8,000. Every time I pay it, it goes down on the 8,000. It showed down to all the way to 2,000 or 1,000. But the invoices for the additional 9,000 she asked for, I never seen that at all until she dropped off the case, and that's when she sent them. I think this year, or like maybe sometime soon. She just sent those. I never got invoices for additional $9,000. It was always 8,000. Kept going down.
You mean 8,000? I'm sorry, please finish. I did not mean to interrupt.
So the invoices that I do have, it shows that I owed the 8 and it went all the way down to, I think, like $2,000 because I paid her cash.
Okay. And I do want to go, that's a 3,000, you testified that you paid in cash, but I just reviewed my client's records and it indicated that it was paid with a Visa. Are you disputing that?
I guess, but I remember paying in cash. I didn't have $3,000 on Visa.
Okay. And these $2,000, two $1,000 cash payments, you said you made them in October and November of 2022?
If I can recall correctly, it's been a long time.
Okay, do you have any receipt showing that my client received this?
No, I don't.
Do you have any withdrawals from a fund? Where did those funds come from?
It would have come from my job. I'm a trucker.
Okay.
So I basically sometimes I get.
Are you paid in cash?
Sometimes, yes. Not all the time. Sometimes I am, or I get a check. So yes, I was at the time. And I had it cash. So yeah, I paid her. If I didn't have it like in a bank account or anything, I would pay her in cash.
Let me just clarify. You're not sure how you paid or where the cash came from? Because you're talking in a hypothetical now. If you didn't, you would have paid in cash?
No, I'm saying I didn't have all the money like in my bank account sometimes. So the way I was getting paid as a trucker, I would get paid cash, or sometimes he would give me a check.
Got it.
So if I didn't have it in a bank account, or he gave me cash at the time, I would give it to him.
When you say he, you're talking about your employer?
Yes, my employer. I work
Okay,
with,
so you are,
KP.
you have an employer. You don't work for yourself?
No, I work for
Okay.
myself. Yeah. I have
So
an
you get
employer.
paid either by check or cash?
Yes.
And when your employer gives you check, there's no documentation to record that he paid you in cash?
No, not really. He give what do you call it? when he gave me cash, I never got like a, what do you call that?
Are you talking about your tax paperwork? Or
Yeah, like a
receipt?
check stub or
Got
something,
it.
but
Okay, so you
like
don't
when
get
I
check
do,
stubs?
like a 1099 at the end of year, it'll be all
Okay, so
on
you're an
there.
independent contractor.
Yes,
Okay, and then, so sometimes you'll have large amounts of cash is what you're saying?
yes.
Okay, so do you specifically remember how you paid the 3,000 in this case?
That was my first payment, and I remember paying the cash. I
Okay.
didn't pay in no credit visa or anything like that.
And when you paid, did they give you a receipt? The Cheltenham law firm give you a receipt?
Yes, I remember having the receipt.
Okay. Did you provide that
And I,
receipt to your attorney?
Yes.
Okay.
Yeah, we got the receipt.
Okay.
Do you have that receipt with you today?
I got a screenshot of it. I think it's in, yes, but it's in my phone, yes. I have a screenshot to show that it was paid.
Okay, wait, you gave me an email indicating that 3,000 was on a visa ending in 0101. That's an email dated April 30th, 2025. But I don't see anything about the two $1,000 payments.
But no objection, that wasn't the question. The question was, is there a document showing the 3,000?
The 3,000, I was only asking about the 3,000.
Oh, I was asking about the two.
You're asking about the
1,000,
two.
yes.
Yeah,
So
I
let me
think
ask
he was
you-
responding to my question.
With this email, does that refresh your recollection that the $3,000 was made by credit card?
Yes, I'm assuming it was. Yeah.
With respect to the two $1,000 payments, do you have any documentation showing that those payments were made?
Not,
Do you have anything showing the monies were withdrawn from your bank account?
no, I was not that I can find.
And is your testimony you physically went to Cheltenham's offices and made that payment?
And I know I did that a couple times.
Who did you make the payment to?
Either her receptionist or her person.
Do you recall which?
Which,
Which
receptionist.
person? Yeah, no, which,
Not especially not by name right now. It's been, like I said, a couple years ago, and a lot of things have been going on.
I'm going to direct your attention to the text exchange of December 9th, 2022. I review this. I don't see that there was a demand for you to pay another quote unquote $8,000. I see there was an indication that you owed the firm over $8,000 and that your retainer was supposed to be $8,000. But where did this demand for this $8,000 come from?
That is the first time I even heard about the additional 8,000. Far as I know, it was always I owe the $8,000. That's what the agreement was. Until that text message in December is when I found out that she wanted an additional 8,000. I was clueless. She never told me.
So that's all contained in this text message.
Yeah,
There's nothing outside this
I
text.
was never told that I owed additional or she was adding on to the case or anything.
But I thought you had previously testified that you had seen the invoice up until the time it was an $8,000 balance, which was I'm
gonna object, that wasn't his testimony. It was, he saw the invoice at the very end in May.
No,
No, that's not what he said. He said he was receiving some in the beginning and then he got some at the end, is what he said.
He did not receive the last one. So
Yeah.
he
But
saw
I
the
was-
8,000. He didn't see anything on the 9 until the end.
When I was receiving
What I
the invoice, it showed that I owe 8,000, and then every time you make a payment, it'll go
It would
down,
deduct
but
it.
it don't say what she's charging me for or anything of the sort, and it never said, like I said, it never showed that I owe additional $9,000.
You have invoices that you received from her office?
Yeah, my phone showed my payment, really just a payment receipt
Were you receiving of the invoices electronically or by mail?
by that app.
Through the app, okay.
Yeah, through the app,
Okay,
it
and
just showed
so,
what you paid.
You turned over to your attorney what you saw as invoices?
Yes.
Okay, so you
That's what
didn't,
you're
your
calling.
invoices didn't look like exhibit
No,
B?
ma'am.
Oh, okay.
What did they look like?
Can I go on my phone and show you?
You want to show you, that's fine. I'm assuming that you have a copy of what his invoice
Yeah,
looked like. Is that
probably
correct,
on
Mr.
there,
Fold?
'cause
The invoices look the same, Your Honor.
That's not what he just said.
What I received is, it just shows like a payment.
Maybe, can you pull up what you're trying to show on the phone and show the attorneys what you're talking about? Because maybe he's talking about something different than an invoice, and that could explain. I'll let him show it to you on, not necessarily for me, whatever you're trying to show them and that you believe was the invoice.
That's. Okay, well, but they're in the form of
Did
exhibit B.
they look the same as this, you're saying?
This is
Yeah.
what I was getting.
Can you show the attorneys?
Yeah, I think that's your case, right?
It's a link, yeah.
Yeah, that's just for the payments.
That's not an invoice though, correct? Is you, what you're saying?
It appears to look like an invoice, Your Honor. It
That's
has a
what I
balance.
thought.
and
It looks
date,
like
but
that.
It does not look like this. It's a different screen entirely.
But he gave you gave them actual invoices, so there must be another way. Okay, so I don't know
Yeah,
what's
I
going
think-
on there.
She did testify that she has a system that you can go on and make payments.
Got it,
It
okay.
shows your balance and.
But you never received anything via mail?
Your email?
Mail or email?
No, I didn't. I received after she canceled from being my attorney and said that that we were gonna go to court or whatnot. I received invoice. That's when I really got the invoice.
Okay, you can continue, counsel.
Thank you. So I'm going back to the exhibit, your defendant's exhibit 2, the text from June of 2022. You had testified that you were upset because you had not seen your daughter, correct?
Yes.
And my client advises you that the reason you hadn't seen your daughter is you needed a psych eval, correct?
Is that a yes?
Yes.
Did you understand that you needed a psych eval before you could see your daughter?
Yes.
Okay.
Yeah. So,
How, and she was encouraging you to get a hold of a Dr. Fugate? And
yes.
when did that occur?
And that was back in June.
June 24th,
Okay,
2022.
so between June and July, I got in contact with him. I just kept calling and kept calling. I got in contact with him and I paid the $900 and got it done.
According to my client's records, she spoke with Dr. Fugate on July 25th, 2022. At which time, and I'm referring on Exhibit B, the invoice date of August 1st, 2022. That she spoke with Dr. Fugate at that time. Is that the meaning that the exam was completed or deemed?
I think we were checking to see.
Okay. You know, do you know when the exam was completed?
Like I said, it had to be between June and July, because when she told me, I made sure I was getting everything done.
And when you were first retaining my client, did you believe at that time, did anybody believe a psych eval was going to be necessary?
I don't know.
Did my client defend a personal protection order that was imposed against you?
Did she defend? No, we never went to court. The mother, the grandmother lied and tried to get one. She did file I don't know if you say a motion or however you call it, but she filed a motion and they dropped it.
After she filed the motion.
Yeah, she did.
Who filed the motion?
Charlotte.
Cheltenham found, okay, so let me be clear, because you said she, so I'm trying to make sure she is not the grandmother. The grandmother, your daughter's grandmother tried to get a PPO, is that what you're saying?
Yeah, she tried to get a PPO again.
Okay, and then Cheltenham filed a motion?
Yes, Shellingham had me go to the police and pay for body cams and
Okay,
everything, so.
and then filed a motion, and then the PPO was
Dropped.
just dropped. Okay, so his prior question was about whether or not she defended you in a PPO.
So that's it, yes.
Okay, thank you.
And was that PPO in existence at the time or being sought at the time that you retained Cheltenham Law?
No,
And in Exhibit 3, you state you terminated yourself,
Mhm.
correct? So at this point in time, it sounds to me like you wanted her to continue to represent.
yeah, I did at the time, but we had a disagreement on the additional $8,000.
So that was in February of 2023. So this person who did this horrible representation of you, according to your testimony, you wanted her to continue to represent.
I was exhausted of money. Like I said, I was exhausted of money, gave her all my money, and I really wanted my daughter. I had my daughter since she'd been 3 years old. And it wasn't, I didn't think that the case of,
And you find that admirable. I have no further questions for this witness at this time.
Just very briefly, Mr. Burton, are you sure you paid Miss Cheltenham $7,000?
yeah,
I believe your testimony was you paid $2,000 in cash at her office. Are you sure that happened?
yes, I'm sure of that.
When Miss Cheltenham asked you, in I believe December of 22, for $8,000, was that your belief that was for a new 8,000 or for the initial 8,000?
For a new 8,000.
Nothing further, thank you.
I have some additional questions. I have text messages here that span about some of your communications. I reviewed the text messages. Did you ever communicate a concern about the quality of the representation you were receiving to Ms. Cheltenham?
I don't recall. I can look through my, our text messages go for months.
You don't, but you
But
can't
I don't,
recall if you said, hey, I don't think you're doing a good job representing me.
I remember saying that once, but I don't know. I don't know. I know for a fact I got it in a text message. So
You got a text message.
Yes, it should be in there. So I know.
When did you send a text message telling her that you had a concern about her representation?
In December?
Of 2022?
Yeah.
Okay, so
Don't you asking?
I'm asking you, yeah, I'm asking you, when did you send the text message expressing concern about the quality of the representation you had been receiving?
Okay, so yeah, like I said, that was basically in December. As far as that, I never like really expressed it to her. I didn't want her to already I was exhausted out of money, so I didn't want her just to drop the case with an attitude, wouldn't or whatnot. I don't know how really lawyers work. So no, I just really just.
Okay, you sent this in text message expressing your concern about the quality of.
In December, yeah.
Okay, and you turned that text message over to your
If I can recall,
Attorney?
yes, I did. If I recall. But there be nothing.
Is that when you said, yes, I don't think you're representing me right, I will find a new lawyer?
Yes.
Is that what you're talking about?
Yes. Yes.
Okay, and did you ever express concern to her prior to that message? Any redirect based on my question?
Mr. Burton, when you expressed, I can't remember the court's words, I'm just gonna say displeasure with Miss Cheltenham, could that have been orally or would that have only been through text or email?
I say through text, maybe orally, because we done got into a couple of heated conversations. It just so happened, I can't recall.
Did you ever communicate with Miss Cheltenham by phone or in person?
Yes, my phone, she called me a couple different times. When I'm at work.
I think you testified to this, but I just want to confirm, you testified you did not enter into a stipulation allowing her to withdraw as your attorney, correct? You did not sign a document, a stipulation.
The stipulation meaning you didn't
At all.
agree to let her withdraw.
Yeah, we went to court and I told the judge it was okay if she wanted to withdraw, she can withdraw.
But that's after the motion was filed.
Yeah.
Yeah, and I know you're not an attorney. We
Yeah,
do
I'm
things
good.
by, if it's agreed, it's a stipulation. Prior to the motion being filed, did you sign a document saying she could withdraw as your attorney?
No.
That's all I have.
Thank you. Maybe it's gonna be excused, Mr.
Yes, sir.
Maybe excuse, sir. And you can call your next witness.
No further witness.
Okay, you can make your argument.
I would like to recall.
Oh, you wanna recall some? Okay.
And redirect to address
Sounds good.
strictly things.
Ms. Cheltenham, you're
Mr.
still
Brooks.
under oath.
You heard Mr. Burton testify about deficiencies in your work product, including one comment that you did not bring paperwork to a court hearing in May of 2022. Do you have any recollection on what occurred here or elaborate on that?
I don't ever remember going to court without paperwork with me, and certainly not in this case. I also have everything electronically on my laptop. We don't carry hard files a lot of the time, but if I'm going to court, my practice is to print off what I need for that day. I would never go to court without any paperwork.
And then with respect to the invoices, I think earlier you testified you mail them, you email them, and then you've got this online access. Do I have that correct?
Let me clarify, it is all electronic. We have, our platform is electronic. We don't mail invoices, but we do email them, we text them, and we send a link where they can log into the system and view them.
Okay. With respect to the email, do you know whether Mr. Burton accessed the emails you sent him?
I do know that for sure. I also know that he logged into the account or viewed it from the account itself, his online portal.
With respect to the emails, how do you know that he received them?
Because I have a reporting process. I don't have it. My case has a reporting process where I can see a history of an invoice from inception, when I send it, how I send it, what date and time I send it, when the client viewed it, and it's date and time stamped and how they viewed it. So if I sent it via email and it says viewed right above it, that means they viewed that email. If I sent it in a text, and I did all three with Mr. Burton, much of the time, and I know that he viewed those invoices for sure.
And with respect to the online system, you also have stated that you have records of him accessing the invoices online.
Yes, and all of that is through recording through my case. It's not just a manual thing I keep myself. it is automated through my case whenever a client enters the portal, whenever a client accesses an invoice via text, there's a date and time stamp attached to it, and then it's reported within the system.
At the inception of the relationship, did you know you were going to be involved with defending a PPO?
I don't recall that. I think it was an issue later for some reason, or maybe after I got the case, but we got it terminated very quickly. It wasn't a significant problem. We did bill for that. I reviewed that in my billing.
Oh, let me go back to the, did you bill Mr. Burton for having to redo the documents that were done incorrectly and rejected by the court?
No, and I just reviewed the invoices before I came up here. Actually, what we did is we wrote that time off because it was our error. And we wrote the time off, it wasn't me that appeared on one particular day, it was Hannah Beck Sawyer, who was an associate of mine at the time. And I know that because the time entry has her initials by it, and she wrote off her time to appear.
And how about the psych eval by Dr. Fugate? Was that something you expected at the inception to be part of the representation?
I knew the case was going to be difficult. That's part of the reason why it was $8,000 retainer. I knew we were going to have CPS involved potentially because there were criminal charges against Mr. Burton that he had in his history. He had been released, but so he was in a different position. I didn't know for sure if we had to help him obtain the psych eval or if it had already been done. And from recollection, I think, if I'm thinking of this correctly, I think he had an evaluation with MDOC when he was there, but there was an order, if I recall correctly, that Mr. Burton had to have a psychological evaluation before he could exercise parenting time. And so that's why we were pursuing the psych eval. And that's why Dr. Fugate was important. I didn't know we were going to have to track all of it down necessarily. I just knew the case was complicated.
Do you recall having heated conversations with Mr. Burton?
Nothing unusual. It's a very, I mean, in any of these cases in dealing with custody and parenting time, people are highly sensitive, their emotions are heightened. And so I work with those people a lot. And I can tell you, I don't know for sure, but I can tell you that I am pretty forthright with people. I'm very frank with people. And I probably had been stern on a conversation. I don't doubt that at all. I don't recall any yelling matches or feeling like, you know, we're on complete opposite sides of things. I recall having conversations with Mr. Burton, telling him how difficult his case was, that he needed to do certain things before I was able to restore parenting time. I knew the judge very well. This is Judge Garcia in Union County. He's a difficult judge. I don't mean that in a bashing way against Judge Garcia. He just expects orders to be followed and things to be done. And I know the evidence had to be there for us to move forward. And so, I mean, to answer your question, I don't have a particular conversation in mind where I felt like James was on the opposite side of me. He was frustrated by the circumstances, and that was understandable.
I have no further questions.
Ms. Cheltenham, I think you called the online system my case.
That's correct.
How do you know that system's reliable for reporting these things?
Well, I guess because I haven't ever had an issue with it personally, so I don't know statistically. I guess I haven't done a background check on it. I know other law firms use my case, other law firms that I work with, and as far as I'm concerned, the reporting has always been top notch. I've never had another client tell me that they paid and I haven't posted it, or that it didn't post within the system. So I don't have an experience that tells me that the reporting is not right on.
Is that the same system you were confused about earlier about the manual payment?
That's the same system I was confused about earlier in reading the statement on the invoice. Yeah.
Do you recall telling Mr. Burton in December in the text message I showed you earlier that if he wasn't going to pay additional money, that he should stop contacting you?
I mean, I think it's in the text message, so that's clear.
Isn't it a fact Judge Garcia had to reschedule one of the hearings because you didn't have something with you that day?
No, I don't recall that. I don't recall that was the issue.
Isn't it a fact there was a hearing that had to be rescheduled because notice wasn't given properly?
I don't recall that. I really don't.
You said notice wasn't given.
Properly.
What are you referencing?
To the other party.
Okay.
Nothing further.
Can you read
No,
Thank you.
We have a 5-minute restroom break.
Absolutely.
you have to go all the way to the
All of
first
it
floor.
downstairs.
10 minutes.
I was gonna say that, you're gonna have to go to the first floor, so. Good luck. And we're back on the record. You can proceed to argue.
Sorry. Thank you, Your Honor. Your Honor, in this matter, I think there's no question the parties entered into the retainer agreement. Each party acknowledges that. I think there's no question that plaintiff provided legal services. Again, each party can not consented, but confirm that. The plaintiff records show that defendant received all invoices issued on this. Defendant acknowledges receiving many, but not all. I think there's no question that there has been no specific objections to any of the charges contained on those invoices. There's no question defendant breached the payment schedule for the payment of the original retainer fee, as well as the retainer agreement as a whole by not paying the invoices. Even with his theory of paying $7,000, his testimony was 2 payments were in October, November, which were well after all the payments were due on the original $8,000 retainer. With respect to the $2,000, Your Honor, that's an affirmative defense. The burden is on him to establish it. I would point out that his credibility, he testified that he had paid that original $3,000 in cash. He later, I don't want to say recanted, but later confirmed or agreed that it was actually paid by a Visa card. He has no documentation whatsoever and wants this court to believe that he received cash from an employer and brought it over to my client, that my client basically took that money without crediting his account. It's just not credible. My client testified as to the money she received and how those were applied to the account. Even though he claimed he had bad service at times, he testified he would not have terminated my client. There was the issue on the rejected filing. My client did not bill him for those services in connection with that. There's just no question that my client is owed under the terms of retainer fee agreement as a result of defendant's default, the sum of $9,268.39. And we're requesting the court enter a judgment for that amount.
Thank you, Your Honor. Our position is that it's Ms. Cheltenham and Cheltenham Law who first breached the agreement. When you look at the fee agreement, it's clear that there's an agreement amongst the parties for a monthly payment of $1,000 a month. And once that's completed, the balance will be due as listed on the invoice. Prior to the agreement being completed, however, Ms. Cheltenham or her firm had Ms. Cheltenham through the text message that we had this exhibit, asked for an additional $8,000 lump sum, which is outside the scope of the direct language of the agreement. Her accountings are confusing. She, I believe her exact words were, quote, "I think, but I don't know exactly," regarding that October 14th payment of $1,000. That does not appear to be credited to the account later. It's Mr. Burton's testimony that he paid $7,000. Our exhibit demonstrates that Ms. Cheltenham did not dispute that $7,000 had been paid in writing. As the court's aware, quote, "The party asserting a breach of contract has the burden of proving its damages with reasonable certainty and may recover only those damages that are the direct, natural, and proximate cause of the breach." I believe we've demonstrated that her billings are uncertain. There's some disputes over the balances and what's been paid. Mr. Burton consistently stated that he paid $7,000. The text messages show that once the additional demand was made in December, Ms. Cheltenham stated that she was no longer going to be speaking with him. I believe it said, "Stop messaging me if you're not intending on paying." That would be a direct breach of the agreement.
Let me stop you there, because you're saying she breached, that's when she breached the agreement?
We're arguing that that's when the breach was made, when she demanded the additional lump sum prior to the completion of the fee agreement.
And you're referencing the communication in exhibit?
Exhibit 1, Your Honor.
Exhibit
December
1.
2022.
I don't know if I'm missing and I reviewed this in chambers while you all had a break. I don't know if I'm missing a page where there's a demand, but what I see on the first page of this text message is, I know I owe you 1,000. I plan on paying for real soon. Just lost my job. I will pay you. And her response was, well, you owe the firm over 8,000. So are you saying that's a demand for $8,000?
Yes, Your Honor. And then if you look at the next, I believe it's page 2 or 3, he says, I was not aware that the total for this was gonna be $16,000.
Where did she make a demand in this text message?
It's inferred, Your Honor, by the $8,000, and my client testified that she told him it was gonna be $8,000.
That, okay, you can continue. I'll make my.
As I briefly stated earlier, Your Honor, the December message says to stop contacting me, but it's not until February of 23 that she files her motion to withdraw. There's another message that we submitted from February prior to the withdrawal where she tells Mr. Burton to contact the court directly. Mr. Burton's a truck driver, but Ms. Cheltenham said she was confused by her own billing entries here, but did not refute the $7,000 that was paid in the text message. So, Your Honor, our position is that we're asking that, based on his testimony of what he considered to be her poor performance, telling him that she was no longer representing him through those text messages, that she did not believe in his case and should give up his child, and that he had to retain additional counsel, that these were all initial breaches on her part, and that there's also disputes over the exact amount of damages, if any, that Ms. Cheltenham should be awarded based on the additional payments Mr. Burton discussed and the confusion of the October invoices. Thank you.
Thank you. Okay, so let's see. Again, the issue here, as stated by the plaintiff's complaint, is whether or not plaintiff is due, I believe, an amount of $9,268.39 for services rendered. The testimony that came in through plaintiff's sole witness, Mrs. Colleen Cheltenham, was that she met with the defendant in this case, Mr. Burton, in sometime in April, and for a retainer. He came into our office after receiving a free consultation to discuss the case, and that the retainer was supposed to be $8,000. I have what was admitted as plaintiff's exhibit A from the retainer fee agreement, which indicates that there is an $8,000 retainer. It also indicates the date that this that the parties entered into this agreement, but also there was going to be a payment plan because Mr. Burton did not have the full $8,000 retainer, and so he was supposed to pay $3,000 upon signing of the retainer, and $1,000 per month. It's what it appears. Beginning June 1st, there should have been $1,000 July 1st, $1,000 August 1st, $1,000 September 1st, and $1,000 in October. And it appears that representation of Mr. Burton in this matter continued for a series of months up until about December, early December, where it looks like the breakdown took place, at least as evidenced by the exhibits submitted. Defendants admitted exhibit 1, which showcases a series of text messages starting December 9th, 2022. And so the context of the communication prior to that is not necessarily clear to the court, but it appears that if I were to believe this was the beginning of the communication, that Mr. Burton reached out to Ms. Cheltenham, acknowledging his belief that he knows he owes $1,000 and he plans on paying it real soon, but that he lost his job. Ms. Cheltenham responds, well, you owe the firm over $8,000, not just $1,000. I'm talking about your overall balance due. The defense has taken the position that this series of text messages constitutes a breach, an initial breach, but because there was a demand for an additional $8,000. The court disagrees. I read the text messages, I've reviewed even the invoices. I don't believe these invoices are unclear. I don't believe the invoices, at least the invoices that were admitted in plaintiff's B, I don't believe that they are confusing. I recognize that the defense tried to hinge on a particular question about why, I believe the question was why something would be manual versus otherwise, and Ms. Cheltenham's attempt to try to explain why it would say that, and maybe she was unclear I don't know, but I don't believe that she is confused about her invoices or the programming. I thought she testified very succinctly about this software that she uses exclusively for her firm called, is it My Files? My Cases, My Case. And this is software that supposedly is readily used by other attorneys in private practice. If the invoices print from this software like this, I don't see how anything could be confusing. It gives a date entry. It gives the name of the client. It gives the type of issue that's being litigated. There's an opportunity for the initials of who's working on the case, the activity that took place, the description of the work, the rate of the hours, and the line total. There is a invoice date on there, invoice number, the date that it's due, the invoice is due, the balance, and a forwarding balance. It even tells you the number from the invoice that it's being balance forwarded from. I think that a layman could read this and understand the nature of the invoice. And if there were certain questions, then I could believe that anyone could have some questions about some things, that could have been easily cleared up by a conversation. For example, what does non-billable time entries mean? Because when I looked at this originally and I see that some of the lighting on the billable numbers were light and not bolded or darkened, I would not have known exactly what that meant until it was questioned of the witness, what does non-billable entries mean? And that it showcases work that was performed on this file that they wrote off to help us offset the overall amount that would have been billed to the defendant for the services. The reason why the court does not believe this to be a demand is because there's nothing in this text message exchange that says, if you want me to do any work, you need to pay me an additional $1,000, or I'm going to bill you an additional $1,000. This very clearly says your overall balance due, you owe the firm over $8,000. She's merely correcting his statement prior that he owes $1,000, which was his belief. And she says, well, no, you owe over $8,000. And if you look at the invoices, he wouldn't be disputing by the time of December that his overall due was over $8,000. The other concern is that this could not be the first breach, even if she was making a demand in December 9th for another lump sum payment, which is not factual. Is because it's not factual that she didn't make such a demand, because there's invoices that showcase here there was a balance that had been forwarded and that he owed over $8,000 since October of 2022. October of 2022, the first breach took place when he had not paid the $8,000 by October 1st. He took the first breach. His retainer agreement, $8,000 was supposed to be paid, and that the final payment of $1,000 for that $8,000 retainer was supposed to be in Ms. Cheltenham's hand on or before October 1st. When we're getting a text message December 9th that I owe you $1,000, even if I were to believe that that was a factual indication of how much he believed he owed, he's not given any testimony or evidence otherwise that would make the court believe that he had made the $8,000 payments by October 1st, which was according to his agreement. In addition to that, The language of the agreement is very clear. It says here that if a balance is due and owing on a particular invoice, payment is due at a rate of $1,000 monthly until the retainer fee of $8,000 is paid in full. He never paid the retainer fee, and it's December 9th, 2022. He still hasn't paid $8,000. It then says after the completion of a full retainer fee payment schedule is made totaling $8,000, client will pay invoices on the balance due listed in the invoice. Never even got to get to that place because he still hadn't paid the invoice, and he's still the full invoice on the retainer, but he's still accruing monthly invoice. There's nothing in this particular retainer agreement that would cause me to believe that Mr. Burton reasonably understood that his bill was only going to be $8. It says in the very next paragraph, or 2 paragraphs down, if the retainer fee is completely depleted, then the client will be billed monthly. Any unused funds left in the client's trust account after all fees have been paid and litigation ends will be returned to the client. The client has noticed by reading this that a retainer fee is just to retain the attorney. That doesn't mean that that's the cost of your litigation in total. That doesn't mean it's going to actually amount to $8,000. It may have come out to less than that. And then they need to return the money to you. But if it comes out to more than that, you will be billed and you're responsible for the bill. And it tells you in paragraph 5 how you are to be paying that bill. And so I don't believe that there was a misunderstanding that the bill was only going to be $8,000 and then there was later a demand. We also had testimony about the software and how it produces or generates, I should say, the invoice. And so I believe that these invoices were generated on the date and time that they said that they were generated. The software seems sophisticated enough, as based on this testimony, that it lets you track when it's sent and received and reviewed by the other party. The defendant testified originally that he received some invoices, but not all, and that these invoices that he received did not look like the invoices that the court has received here in Plaintiff's Exhibit B. But upon further questioning, we find out that that's not the truth. These do look like the invoices that he received, that these invoices that he received were received electronically. And if he received some, not all, maybe there was a user error, maybe he didn't go in and open them. But the testimony we have from Ms. Cheltenham is that she could see through the software where he viewed those invoices. So I have no reason to question that. And even if I did, I think that the communications that took place in December 9th clarifies that obviously she's under the belief that he's been getting an invoice. And it says right here, I'm saying your current invoice is over $8,000. You know that because you've seen every invoice I send you every single month. So she's communicating to him in December 2022 that I've sent you an invoice every month. I don't see where he says, I have not received any invoices from you. I have no clue what you're talking about. That's not the communication. The other issue that I have is the testimony that there was a dispute or concern about the nature or the quality of Ms. Cheltenham's representation. I don't know. I don't do family law. I wasn't there. I don't know the quality of a representation. But I do know that I cannot accept the testimony of someone who doesn't know what a stip and order is to tell me whether or not someone did their due diligence in court. And when asked about a stip and order, he had no clue what we were talking about. When he testified that Ms. Cheltenham had a motion that was rejected because the language was wrong, that was inaccurate. That wasn't even what she stated here in her text message about the issue. It was the order that was objected, and it was an order that was essentially going to be stipulated to, is what it appeared like. And she never even charged him for it. And so these are non-issues that should not even been brought forth, or could have been flushed out even through your consultation with people who are representing you here today. That she didn't charge you for this. This is not an issue. There was nothing here that shows me that she gave a quality of representation that fell below the standard. And obviously, the state bar does provide an avenue for you to dispute your bill if you believe that there was an overbilling or anything of that nature, but that was not the case. Not only do I believe it wasn't the case, there was never a mention of a concern about the quality of representation until Mr. Burton realized he owed $16,000. And then it were immediately reverted to, I don't believe that you are representing me right. I will find a new lawyer. That was his statements. She responded her disagreement, and she also responded that she would send over a stip. I see here where there was a concern about trying to get the stip, and I think she testified that they tried to get a stip in order to sign at least 3 times. So when the defense questioned about the gap in time between December and her not actually getting an order until later, well, it was your plaintiff that caused that delay based on what I have here, because she said I was in the stip. There's testimony where she appeared to send a stip, and then the records clearly reflect through the text message that she even sent an unsigned stip to the court to try to get withdrawn based on his statements and his unwillingness to pay the bill. And the court said, we can't accept this because he's not signed the stipulation. So she now has to move forward with a motion to withdraw, to which the court granted. Lastly, I think the other concern is there was never even a question about whether or not she represented him on a PPO. We asked him, did she defend him in a PPO? He says, no. This is the person that you brought to court to try to get the court to believe that the representation fell below the standard. Maybe if he had brought the new attorney in to maybe testify, if there was an objection to that, maybe that they could have discussed some deficiencies, but there's nothing that I see. I reviewed the billings. I don't see anything in here that would cause the court to believe that there was a deficiency in the representation, that there was neglect in timeliness of when things were filed, that when things went wrong or things were going a certain way, that Ms. Cheltenham, at least in the limited text messages I have, did not communicate this with the defendant. I see here, even in some of the description of the services provided, where there was communication, keeping him abreast of what was going on. And then there seems to be an abundance of charges that she wrote off to assist him. I'm not saying that the bill was meager, because this is definitely an extensive bill to have to pay this kind of money. And I don't know why, once he received a new attorney, the case was resolved within 2 court hearings. But just because the case was resolved within 2 court hearings does not indicate that the attorney that was previously on the case did not do their due diligence. It could have been an alley-oop. It could have been the case was worked up. You now have had the psychological evaluation that needed to have had. There was countless communications, which the court could see here, that was billed with the other party, with their attorneys, and negotiating and stipulating the things. And maybe the other attorney was able to come in and close the deal, and maybe the deal could have been closed just as quickly had there been a continuation of the services. That is for the defense to have established, and the defense has not provided me anything but some text messages that they believe hinged or showed the court that there was a demand. There was no demand here. There was a clarification that no, you have been billed monthly invoice, and you owe us over $8,000 at this point, and you've already breached. They didn't say this, I'm saying this. You already breached, because you should have already had paid, by the time they received this text message, should have already paid your $8,000 retainer. We've not yet received that. And then even in the latter communication in February, Mr. Burton is not, again, indicating that he doesn't want Ms. Cheltenham to represent him, and that he believes that Ms. Cheltenham services was not quality. He is operating in February as if he believes that he's still represented by her, which is a bit different. If you said here previously in December 9th that I don't want you representing me anymore, I'm going to get a new attorney. You said that in December. So why are you reaching out in February acting as if she's representing you? I also don't have anything that would support that he made these cash payments. That's the burden of the defense. If you are saying that he made these payments, then you got to give me something. And I don't know that his testimony is credible, because we asked him how he made the deposit he told us it was in cash. He was adamant that it was in cash. He said, I had to ask him. I said, do you have any like receipts, or did they give you a receipt? He said, yeah, I got a receipt. I said, did they give it to your attorney? Yeah, I gave it to my attorney. Only for the attorney to turn it over, and it is actually what the plaintiff said it was, which was not in cash, it was a Visa. And so if you can't even remember how you made that payment when you provided the receipt to your attorney, I can't now reasonably believe that you made some other payments that was not reflected, that you don't have any receipts for, because who's giving out $1,000 and not getting a receipt? I'm not giving anybody $1,000 cash. I don't care if you're an attorney or anybody, and you're not getting me a receipt immediately. And that you're getting paid in cash, and that you don't have a way to reflect with certainty that this is how you paid and these are the dates that you paid. That's not been properly pled or supported on this record, so I can't give you credit for that. So in this point, I have no choice but to give favor in judgment for the plaintiff in total $9,268.39. Plaintiff, are you able to produce an order? Do you have one, or do you?
I have, I don't know, I'm working with a new assistant.
You can produce it under the 7-day rule.
I'll do
And
that.
you do have to
She
file
gave
it in
me a
my file.
default,
We don't
yeah.
want it rejected.
Yeah.
So what you want to do is make sure the captions and everything is clear, because the simple will reject it.
Yeah, she gave me a default judgment for some reason, so I'll get it submitted on this.
Thank you. Here are your exhibits. Is that the door? Oh, she probably won't know why we're still here.
Have a good weekend, Your Honor.
Have a good one. Thank you.
Have a good holiday
Have
weekend.
a good one. Thank you.
Oh.